I need to work on. Okay. Hi, everyone. I am going to start with a roll call. And I know Jody's not here today, but Karen, are you here? Let me put this on.
I'm here.
Yeah, great. Let me just get my panel. How do I get? Oh, I guess we have it. Oh, there we go. Thank you. And Jody, I don't think is here. Lucy, are you in with us?
Yes, I am.
Great. And Renee?
I'm here.
Great. Oh, I just lost the big screen is the middle. Larry, are you here?
Yes, I'm here.
Anyone else have a gray screen in the middle of there? Yes.
Yes.
I don't know what that is. Okay. Austin, are you here?
Yeah, I'm here.
Okay, great. And Marisha?
I'm here.
And Kevin? Let's see Kevin. But...
Yes, I'm here.
Oh, great. And Senator Smith?
I'm here.
And I'm here. And Brandon?
Here.
And Casey?
Yes.
Great.
I'm here.
So welcome everybody back to our conversation. I'm assuming, so let me just first ask, does anyone have any questions about what the secretary went over in terms of our next steps? What we're going to try to accomplish. I should say that I consider our group a little bit easier because, as she said, we had multiple proposals, and then the working group took the opportunity to sort of create themes for the proposals because there was some iteration on the theme, and ours boiled down to 2 separate proposals. So we don't have to do a lot of voting. We just need to talk about it. And those 2 separate proposals really are the borrower bill of rights and ombudsman or student advocate, and then predatory lending. We have some really nice research from data collection from Nick Hillman, and also Kevin McShane did a piece on federal advocacy, and both of those topics I think are underpinning some of the work we're going to talk about today, and will be larger topics that will go into the report. Because they sort of cross all of the work groups, right? That data collection, that federal advocacy. So we're going to talk about those and make sure they're top of mind. But in terms of our voting, we're really just looking at borrower bill of rights and ombudsman, and then the regulations, the need for regulations around predatory lending. So we're going to talk a little bit about that. Last meeting, we got through, we spent the majority of our time talking about, oh, right, I'm sorry, we have a new, Nick Hillman is not with us today. Instead, we have our resource person is also from the STAR Lab. She's an assistant director. Her name is Audrey. Audrey, you want to introduce yourself?
Thanks so much. I'm sorry to interrupt. I just wanted to let you know that I'm here. So my name is Audrey Peak. I'm the new assistant director of STAR Lab at UW-Madison. This is my 2nd week on the job, and so I'm just thrilled to be able to jump right into the exciting work that you're student loan borrowers. If you have any questions about the report that Nick and Kim authored, I would be happy to collect those and send them their way, but I can also try and address them here live on the call. Thank you so much for having me.
Audrey, I'm glad you're here. We appreciate it. And Nick was a really great resource during our last conversation. So thanks for chiming up and introducing yourself. Sorry I didn't do that top of the hour.
Not at all.
But
Thank you.
Here. And we could start with that. Just quickly, so what to recap, last week we did or meeting, I should say, we did cover a lot. We had spent the majority of our time talking about the Bar Bill of Rights and Ombudsman, and we did not get to the for-profit piece or the predatory lending piece. So my thought about this afternoon, we have about an hour and a half. I thought we could have a substantive conversation about the for-profits, since we didn't have the time to get to that, and then use the worksheet to sort of go through the programming that we've been talking about, the Borrower Bill of Rights. Use that worksheet to sort of drill down on some of the concerns and the advantages and the disadvantages of these two programs. But before we dive into that, if people did have an opportunity to read Nick Hillman's piece, does anybody have any questions for Audrey about that report? If you had time to read it, I know the task force has sent out a lot of material to everyone, and so maybe we haven't had an opportunity just yet. But if you have, Audrey is your captive audience right now. So if you have questions for her, well, you can certainly go back to her. It's a great report. It's very interesting. And, I will say one other thing we talked a little bit about last week, and we should continue to talk about this week, is race and inequity and borrowing and lending and student debt, and how we should build that into our recommendations. Again, that is similar to the data collection and the federal advocacy. We see that coming across all lines of the work groups and really needing to be taken into consideration. So I think last meeting we did talk about revisiting that issue and whether there was specific ideas. I don't believe there's any specific ideas on the table about how to address that, as much as it needs to be baked into whatever proposal we have. But feel free to correct me or enhance that. So with that, I'm going to open it up to the group to talk a little bit about the predatory lending and the for-profit regulatory framework. And if I recall, there was a paper or a policy piece that was written by Michael Rosen. Did everybody have an opportunity to take a look at that? In his piece, he had recommended that the state adopt a toolkit of best practices. I think the state of Maryland has done so. And so, did anybody have any feedback on that particular proposal? Cheryl, I don't know if you have it at your fingertips. Maybe you could pull it up, because it's a 2-page proposal, but at the bottom of it, there's a series of best practices. There's about 6 best practices that are listed. And I'd be interested in hearing Casey's feedback, because some of it may be, in fact, already in place at the EAB. Do you have that, Cheryl? She's on mute.
I'm having technical difficulties. Sorry. Yeah, I'm in the process of bringing it up. So
Okay, great.
No, yeah.
Great. So while she's bringing that back up, the other I think proposal that sort of complements this conversation, and that perhaps we should talk about in the same context, is the request from Senator Hasselbein to reinstate the EAB. And Casey, I don't know if you saw that.
Yeah.
I know you still exist in some form, obviously at DISPUS, but if you had any thoughts on that proposal, and did you have an opportunity? If you had an opportunity to look at that, it's pretty specific about some of the things that she thinks should continue to happen. And I'd be curious to hear what in that proposal is not happening.
Yeah, I am happy to kind of jump in on this. I don't want to insert too much of an opinion, but can clarify, answer questions about what's happening, what's not happening. Having been with the EAB and then now the EAP, I've seen sort of both sides of what's happened. And I think I'll preface everything with saying that the department now has inherited something that is a huge undertaking and has done the best that it possibly can with limited tools and limited resources at our disposal. That said, I do see differences in the ability of the EAB to protect consumers. Having a 7-member governing board that isn't available at DSPS, being more spirit of the law oriented, I suppose, rather than DSPS, which has historically been more comfortable looking at the letter of the law. I see both sides of the coin. I'm happy to sort of expand on things that I see happening and not happening. But I'm not particularly in a position to insert too strongly of an opinion here.
I have a question. If it in relation to the proposal for EAB, how would that either complement or be duplicative of the recommendations around the student loan ombudsman kind of student loan advocate group? Because if we're setting up these groups that are established to protect borrowers from fraudulent practices, if we recommended both of those, is it duplicative or not, in your opinion?
I don't think it would be duplicative. I think it would be probably easier if we were setting up something, constructing something. You could take a multifaceted approach and kind of have one set up, one office, let's say, encompass both functions.
Okay, thank you.
Yeah, Cheryl, if you want to either share Michael Rosen's suggestion or the proposal dealing with the EAB, the reinstatement of EAB, either one.
The one I have up right now is Michael Rosen, and then I can bring up the other one. So you want me to just go to the recommendations?
Yeah. Although, actually, do you mind? His is a little distinct. Do you mind bringing up hers really quick? Just
Sure.
because I think that it's very succinct.
Let's see.
So Kevin, I think with respect to the student advocate and the ombudsman, they're a lot of those borrower bill of rights and those regulations are directed at the servicer. And then they also are directed at the institution in terms of keeping students up to date on their loan, payments and what have you, which I thought was an interesting. I thought that was interesting, but Representative Hasselbein's proposal is about reinstating the EAB to address, to regulate institutions, and I think it's in response to some of the deregulation on the federal side, about disclosures about employment rates and graduation rates and that kind of thing.
Yeah, and part of my question on that would be, I think just as you define the scope of a student loan ombudsman, because a lot of times I think what the byproduct is that there's certainly the regulatory components or legislative components that you would put in that people have to abide by, but then I think it does become a little bit about enforcement and how that works. So my question was more, if a student had a complaint or if there was a body overseeing this, would that all be to one entity, or would a student say, in this scenario, I have to go to the EAB, in this scenario, I have to go to the student loan ombudsman, in this scenario? Because again, part of I think collectively what we're trying to solve is eliminating the confusion for the consumer or the borrower on how they can get help when they need help, how they can file complaints when they need to file complaints. And sometimes my concern is if things are overlapping or duplicative, even if they're not meant to be by policy, that it creates these layers of confusion that students can't navigate. So that was part of what my question is on that side of it.
Yeah, I think it's a great point. And one of the things that the secretary mentioned in our meetings before this, and also I think she mentioned it in the setup here, was not to focus on the what and not the how. But in this instance, I feel like, and we spent a lot of time talking about this last time, I think the how on some level is important in this conversation because it really gets at what you just said, this iterative nature and people not knowing where to go to get the right resources, and your piece on the federal advocacy, sort of like gets at that too, right? The streamlining of who's in charge and who, the simplicity, the lack of simplicity. And, that was again in the vault presentation, the number of servicers, the number of interest rates, the number of, right? It's just so convoluted at every level. So like, I guess I hear you saying if there's a need to have an advocate, having a convoluted structure of an advocacy role that depends on where you are in the process, that depends on who you call, would be an important consideration for the governor as he tries to address these problems. So, yeah, I don't think it's this one. Are you?
Yeah.
I can find it.
Okay.
Real quick here.
Sorry, I tend to have all 37 of them. So trying to sift through them.
I'll see if I can find it.
Casey, can I ask you a question?
Mm-hmm.
So I know you do a lot on the front end of approving schools or for-profit schools to operate in the state, and it's the beauty schools, taxidermy. I mean, you really cover the whole gamut. Once the school is approved and you have all that documentation in place, do you ever go back? Is there any sort of requirements of that school? Do they come back to you annually or to maintain this approval to operate in the state? Or is it a one-time shot?
So there's an annual renewal cycle. Through that cycle, we're largely verifying, contact information, but also collecting student outcomes, some basic information about, total tuition that was collected from Wisconsin students in the prior year. And we, are able to ask questions if we see red flags. That said, where I've seen the issue come into play is if there is something that is glaringly problematic, where the enforcement authority rests in our ability to pull a school's approval. So I think once they kind of get through that gate, it's very challenging to rescind approval. So there's those benchmarks in place, but how much do they mean if you can't hold them accountable?
Okay, so I'm just going to read this. It's pretty brief. So Representative Hasselbein's suggestion of reinstating the EAB would be inclusive of evaluating and improving institutions offering post-secondary training and education, supporting options for innovative and quality programs offered by institutions, and collecting and disseminating student outcomes and information. I wonder, Casey, if much of that is being done except for the collection and dissemination of student outcomes.
So I think it's worth pointing out, so when the function is transferred over to DSPS, essentially what the governor and the legislator did is they picked up our consumer protection functions, the statutes, and moved them over to the new entity. So all of those legal pieces, that framework is still in existence. The difference lies in the fact that we've been very limited now in resources to perform the functions, position authority that under the previous administration maybe was reallocated to other areas, other needs in the department, and then not having that 7-member expert governing board to oversee us. I think all of those things are what are contributing to the difference between the then and the now, not necessarily what's written into law. So I think I understand where this proposal is coming from, because we're limited in what we are able to do now with the resources that we have compared to previously.
Casey, with the EAB, do they have any sort of audit functions?
No, not audit in the sense that I think you may be implying. There would be, we could conduct site visits, we could show up at schools announced or unannounced if there were issues, we could review files. That is something that I would say does not occur much presently, though it was once more of an integral practice. But there's not the, you get audited once every year or 3 years, like an accreditation site visit.
And I asked that question just because you made the comment where they get approved, and then after that, you don't really have any teeth after that. So I'm just wondering what maybe can be added to maybe some of your statutory authority that's going to give you some of those kind of strength in making sure these institutions are being compliant, and maybe it's not just in state regulations, but it could be in federal regulations as well. You would have maybe that potential of looking at not just those state laws, but federal compliance laws as well.
That might be a good opportunity for Cheryl to bring up Michael Rosen's paper, because that does have 6 best practices that may be best housed in the EAB, sort of getting at what Brandon was talking about. So at the bottom of the paper, he has the practices listed out. It says 7, but I think there are only 6 there.
there's only 6 best practices.
Yeah, we can fix
I'll
that.
scroll back up to the first one and then slowly scroll down so that people can read them.
How do folks, if everyone's had a chance to sort of skim these, does it make sense to go through them one by one? Talk about them a little bit.
Mhm.
So let's start with number 1.
I guess, could I ask a question to Casey on this first one? Is there any state requirements where the institution has to get bonded, where they have to pay for an insurance bond, where if they do close, it would assist in covering any teach out requirements and any tuition refunds or anything of that sort?
There is a bonding requirement. The maximum bond that the state of Wisconsin can require a school to hold is $25,000. So in terms of, wiping away student debt, that in many circumstances, $25,000 would only cover a student.
Right.
We have notably our Student Protection Fund. That's a statutorily required pot of money that has to sit at a minimum of $1 million and can be used to indemnify student losses in the situation of an abrupt closure, where students are hurt by their institution. That is generally used to supplement guidance that we're pushing students into transfer possibilities or loan discharges on the federal level, but that is a big consumer protection piece that remains.
Do you think it's strong enough as it is, or do you think that could build? I think that kind of fits into this best practice 1. I don't know if the group agrees or not, but maybe it could just be built off of that, whatever's in place.
And so that's for any school, right? To operate those qualifications, truck driving school, beauty school, right? I mean, that's the standard or the minimum, correct?
In terms of, my comments, it's any school that we approve. So not taking into account all of the exempt institutions, which are more than the approved ones.
Right.
So a school like University of Phoenix no longer reports to the state of Wisconsin. So if hypothetically that school were to close, we wouldn't be able to step in with these funds and assist students.
But
That's
Bud's office.
I'm sorry, can you say that again?
But if we had an ombudsman's office, they could assist that person in obtaining that closed school discharge through the federal government.
Yes, so we more so utilize the protection funds for private loans, which there isn't that automatic discharge process. And we have in the past, so Anthem College was a school in Brookfield, Wisconsin that closed. And we used those funds to basically pay to keep the school running for an additional couple of months to get students through their program. And I can't tell you the final number, but we paid between $400,000 and $500,000 out of the fund just for that purpose.
So I was going to say, I think the exempt school issue comes out of the Sarah Pact, and I think there's a best practice addressing that as well. So is everyone sort of the mind that the best practice one, are we in agreement that it would be useful to expand that and build that back into the EAB if we were to?
Can I ask a clarifying question on that? One, I really like the best practice, but I do want to point out I'm pretty sure in Maryland this applies to all schools, not just proprietary schools. And then in addition, well, I know Michael Rosen's paper discusses some of the, that he described as a weakening of the federal protections. In my opinion, this is one of the things that actually got strengthened in the federal protections was the school closure process. So I think just however we would recommend or set that up, we would want to be careful because the paper is labeled proprietary or we're talking about under EAB, but there may be an instance where this makes sense to be uniform across the board. There's also a lot of the national studies and predictions on school closures predict a large number of small nonprofit institutions going out of business and again closing. So I think in the context of borrower protection, is there a reason this would be isolated to EAB or only proprietary institutions, or would this make sense to be a recommendation for all institutions?
I think that's a great point, Kevin, because you could argue the level of depth, but we, the EAP, are already doing many of these things in best practice one, but that's limited to the 180 schools that we oversee, not everybody else. So I think that is an important point to highlight.
So Kevin, are you familiar with how Maryland's has been deployed? Like it doesn't cover public institutions, it just covers private institutions, right? So it covers like.
Yeah, I'm not 100% sure. I would have to brush up on exactly how it's worded and how it works, but I think it does apply to all colleges in the state, but I don't know the nuances of it.
Okay. No, I think that's an excellent observation. And I think that's right. With COVID, we're going to see a lot, especially now that many of them are not opening in the fall, except for online. I would imagine a fair amount of them are going to close. So does anybody have any feedback on that recommendation that the best practice one sort of be expanded to all private institutions, both nonprofit and for-profit? I don't think we could loop in the public institutions. Anyway, I'd have to go back and look at Maryland to know best. So I want to move through this because I do want to do the worksheet a little bit on some of our recommendations too after we get through them. And then I know also, Karen, you have a paper of another recommendation on a legal advocate that we should talk about as well.
Can I say something else about Michael Rosen's proposal?
Oh yeah, we're not leaving it. We were going to go down to best practice too, but go ahead.
Oh, okay. Well, I'm not sure which best practice this would fit into, but one of his stated goals was to address the marketing practices of for-profit institutions. And that's what I feel like could be enhanced in these best practices. It talks about limiting the amount of money that institutions can spend on marketing, but it doesn't really talk about predatory marketing practices. And here's where I feel like the proposal I submitted could be folded into here. Specifically, predatory marketers that are targeting low-income students of color who in my proposal, I give a variety of examples of types of keywords and searches that they're doing for harvesting that data on how they're finding vulnerable students who they think will be most eligible for student loans to help pay tuition. So I would love to kind of see a consumer data protection rolled into this proposal around cracking down on predatory schools and their predatory marketing tactics, both that they perpetrate, but also that they work with people like lead generators to buy names very cheaply of students that can be targeted for these institutions. So those are my thoughts.
I think so. For everybody's clarification or edification, Renee submitted the piece on the data privacy, the Consumer Protection Data Privacy law, and I think those are great suggestions. I think some of what you're talking about might be in best practices 6. It could be enhanced there because that talks about spending. And then I also think in best practices 4, and Casey, you might correct me on that, it talks about SARA oversight. And my understanding of SARA is there are issues having to do with prohibited practices of institutions as well, which would include predation on vulnerable communities, but a targeted, explicit directive on marketing, I think, is would be interesting and important.
Yeah, and I think this problem is only getting worse with the amount of data available on the younger generation and the amount of data that has been collected through smartphone use. I mean, schools can target very specifically who they're looking for and not spend a lot of money doing it. So I think just limiting their marketing budgets isn't necessarily doing the best to protect those vulnerable students.
Yeah, I think that one of the things you're going to run into with marketing, you know, you can get at it from a budgetary perspective and then prohibited practices, but then you're going to quickly bump up to First Amendment rights, right? So like, you know, prescribing what they can't say and having, you know, so like, for instance, a lot of the outcomes, the beauty of having these required data outcomes is that when they do, what you often see with these predatory schools is they misrepresent their outcomes, their, you know, for students' graduation rates or employment rates or expected salary, etc. So if you have the requirement that they have the data, you have a requirement that they disclose how much money and maybe a limitation on the marketing budget, and you have the prohibited practices about what they can't say, you can sort of get at it from different angles in these best practices. But you can't, it gets a little bit more complicated legally if you're telling them they can't say certain things, if it's or target certain groups, if, you know, there's nothing illegal about deciding to go into a community and try to solicit one group over another. It's done all the time, right?
Right, but a lot of the data practices are not transparent right now, and they're highly unregulated in the US. So we have private companies who are buying and selling student data without the student's consent or notification. And there's an overall lack of transparency around this sort of predatory marketing practice. So I think at minimum, if we could have regulations that increase the transparency in how for-profit schools are getting their leads, and to empower the borrowers or the students to be able to opt out of that data collection or the sale of their personal data, and then being able to offer a path of recourse if a student is targeted, and there's a documented process that has been created through these regulations that they could then file suit for having their data being used incorrectly in a predatory manner. And this is the type of law that's been passed in California and went into effect in January. So it's still pretty new, but it would be, I think that more states should be moving towards this because it not only affects student privacy from for-profit predatory schools, but also predatory lenders in other sectors, and it kind of would cover multiple sort of predatory practices across the industry.
I just wanted to respond a little bit to that. You know, the opt-out for me, I have a lot of concerns about that just based on my experience with my own clients. I think that my client population, which is who we're aiming this at, is extremely unlikely to be able to opt out without a huge PR push to make that happen and literally people to be hands-on to assist them. I just don't see my low-income African-American population of clients being able to do it. So I have a lot of concerns about that, especially based on all of our failure to opt out of mandatory arbitration, which is also a large anti-consumer problem in this country. So that's just my 2 cents.
Yeah, and the European Union doesn't do opt-out. The sale of information is an opt-in. So no sale of personal information can happen in the European Union. So that is a different model that would be more strict.
So I will just say, in my other life, I'm running a committee at DADCAP on data privacy, and we're coming out with our report in August and September as well. And I'm very familiar with the GDPR and CCPA out of California. Those are very expansive bills. And so one of the questions I have in response to your thoughts, Renee, which I think are salient, and I agree with them, is if we want to think about this in a student loan context, the collection of data and by proprietary schools, you know, I'm not entirely familiar with what FERPA requires in that regard, but my FERPA is pretty strict about data. That's the FERPA is the Education Act. It's the, what does that stand for? Federal, does anybody else have it top of their head? Education Reform Privacy Act or something like that. Education Privacy Act. I can't remember right now. But in any event, there's a lot of requirements in FERPA about keeping consumer or student data private. So much so that when you're investigating these schools, it's really hard to get it as a state regulator. So what I think you're getting at is more the lead generation and the targeting of the students, which wouldn't be done by the, which would be regulating a third party, not necessarily the schools, like by the time the schools have enrolled them. When you're talking about sharing data. So I think that might be a little far afield from what we're talking about right now, or I'm just trying to figure out how to bake it into the best practices and different than what we talked about in terms of prohibited practices. Do you know what I'm getting at?
And I just wanted to just make mention of the fact that this best practice for, talking about what's been enacted in California, worth pointing out that California is not a SARA member. So they, in many regards, have more flexibility in the regulations that they're able to apply to for-profit schools. By being a part of SARA, we have sort of forfeited a lot of that. going back to this conversation of what can we require schools to disclose or what they can't advertise, there's not much that we currently can do about schools that fall under Sarah.
I just question more like clarification, but like for like data protection and the way in which it's marketed, is that something that could fall under like a student loan borrower bill of rights? Maybe not so much like borrowing, but just like trying to think how to word it, but like it's in regards to consumer protection, like your data being like misused. Like, is that something that could be incorporated, or am I misassociating the two? I just was curious on everyone's thoughts on that.
I like that idea.
Do you, Casey, are you familiar with Massachusetts Memorandum of Understanding in the context of Sarah?
No.
So it does sound like the two options under best practices 4 is either you recede and do what California does, or maybe you become a more active member and you have this memorandum of understanding so you can sort of bolster your consumer protection laws. And I wonder if that's what the MOU with Massachusetts does.
It's possible, and I think it would be an easier, it would be more attainable if you had consumer protection laws that applied across the spectrum, so not specifically just to the for-profit schools. I think that that would be an easier, less controversial sell, maybe. But I can't speak to the specifics of Massachusetts without looking into it.
But just to be clear, if we were to pass something or seek a best practice that applies to all schools, we'd have to have an MOU to get it applied to proprietary schools because of Sarah, right?
Yes.
Okay, so it would be a 1-2. Austin, in terms of what you were talking about, adding protections into the Borrow Bill of Rights with respect to prohibited practices, I think those are really geared at lenders and not at for-profit institutions or proprietary schools. It's not really, they're not really geared at institutions as much. Isn't to say that we couldn't do that, but again, I think FERPA has a fair amount of protections in terms of protecting consumer data once the student is enrolled. The question becomes what, I think the question that Renee was getting at is the targeting of students, of potential students, and the, that, you know, I think we would be preempted if we tried to do a lot of regulation around the use of student data, because as I say, I think that's pretty much covered by under FERPA. Isn't that right, Karen? Don't you think?
Yes.
Yeah. So in terms of marketing practices, though, I think that would be something we could bake into these best practices. So should we move to, did we do best practice 3 yet? Oh no, we didn't do best practice 2 actually. Let's go back to 2. I think we did a little bit of, we moved around.
So Kevin, I have a question to you about 9010. So it's said at the Fed said that, but the states have the right to set their own measure to that. And then I guess, you know, like to what Casey was saying, you know, we have a number of schools that operate in this state that are already exempt. So what, we couldn't have any protections against those exempt states or those exempt institutions, correct?
Yeah, so right now that is a federal regulation that only applies to proprietary institutions, to for-profit institutions. There are discussions in Congress to adjust that as well, and I think that's partially what I don't want to speak on his behalf, but I assume that's what Michael Rosen is talking about, is that the federal government is slow to act or waiting to act, so that the state should do something in the meantime. But what it does is restrict your access to Title IV financial aid. So I don't know that the state would have any authority to revoke your ability to get Title IV financial aid. So you would have to tie some piece of legislation or regulation in the state to the EAB approval of your institution and staying under that number. I think there might. I'm not a lawyer, so I want to clarify with that. But I think it would get pretty complicated on that front. But you may be able to do something there.
Okay.
Well, Larry already checks their 8515 rule when it comes to the GI Bill, so we could just have Larry do this. So sorry, that's insider baseball. I would say that maybe for Brett. Go ahead, Kevin.
I was just going to say, I would think I know we don't want to get too far into the details, but I think if you tried to do something here, you would want to have a caveat that if the federal rule becomes the same or more restrictive at any point in time through legislation, that it would override the state rule, because you wouldn't want to get into a situation where you're allowing something that's actually a higher level than the federal government's offering. So I think you'd have to think about that as well if you did something here.
I got to ask a question. So just to clarify, the loophole is the lack of enforcement. Is that what we're saying here?
No, what happens in regulation right now is it essentially says that no more than 90% of your revenue can come from federal Title IV financial aid funds, but that does not include GI Bill funds or other veteran-related funds. And there's a lot of people that believe that the entirety of federal funding should be included on the side of the 90-10 rule. And then people also believe that maybe it should be 85-15 or 80-20 instead of 90-10. So that those are kind of the 2 points that people typically make.
Okay. All right. Thank you.
And maybe we could.
Oh, go ahead, Brandon. Sorry.
I was just going to say, maybe we just put this in our federal advocacy piece. I mean, I just don't know if this is something we want to get involved in federal regulations, and if they change things and we put these things in law, kind of to what Kevin was speaking to. And maybe this is more of an advocacy and something that could go in a different bucket, a different policy.
Well, and I know that veterans groups are working really diligently to try and deal with this situation. So I think it's probably going to change soon, but I agree that it would be part of the advocacy piece.
Yeah, and I'll just say it can also be part of the transparency piece in best practice 6, I think, about transparency about spending and where it's coming from. Because my experience in litigating against some of these schools is that, if they target a cross section of the community that is all Pell Grant eligible, their tuitions are often set at the amount of money you can get from the federal government, and then they add on private lending in order to meet that 10% aggregate. So it's a complicated. It's got some unintended consequences, I think. But in any event, I think maybe we could get at it a little bit with best practices 6 by just knowing like where the money is coming from and who they're targeting and the finances of that. So we're going to table best practices 2. 3, what do we think about 3?
Is anybody more familiar with Maryland's law on this? Is this more of like an IRS regulation on if people are improperly paying people through a nonprofit organization? I guess I don't understand. I'm not familiar with their law, so it's hard to comment on.
I don't understand this either.
Yeah.
Yes, because I think legally speaking, from an IRS standard, if you're a nonprofit institution and you're somehow generating income and paying private individuals, I mean, I think that would be tax fraud, and I think you'd have other issues. So yeah, without understanding their law or the purpose of it, that one's hard to understand.
I agree with Kevin.
Yeah. And
I
since
think
we're
what
going
this-
to try to move through and let's move to, we'll table. Oh, Casey, do you have some thoughts on that?
Well, I think that what this is getting at is this trend in higher education over the past 5 years, and is likely to continue, of traditionally for-profit schools switching their governance structure and qualifying as nonprofit schools, where then they're able to, operate under available exemptions. And where we stand and how we can deal with this, I think that may be a much heavier lift for another time, but I believe that that's what this is sort of poking at.
Okay. Why don't we table that and go to best practices 4? We talked already. We touched on this a little bit. Does the group have any thoughts on our continued participation in Sarah, or whether or not there's another approach or an ad hoc, some sort of combinations? Maybe have thoughts on that.
I was in when I first saw the potential of getting out of Sarah. I'd like to learn more as to how difficult that might be. Maybe Casey knows, or I mean, does it take legislative action, or is that a WEA thing, or how does that happen?
There was legislative action to allow us to enter Sarah, but we have our distance learning authorization board in Wisconsin, which is comprised of representatives from each of the sectors of schools. So they signed an agreement to enter, which was made possible by the law. I do not believe you have to change the law to withdraw. That just allows the flexibility, I guess, in making those decisions. That said, I understand there's been ongoing discussions about the value of Sarah to our state and our students here. There are likely, certain individuals that benefit more from being a part of Sarah, certain schools than others. And so in terms of the for-profits, that was always a concern. And the EAB was vocal in its opposition to Sarah. And I think we're seeing the reasons why right here.
And I guess anecdotally, I have a colleague who participates in the NC Sarah conversations, and I don't know if she's officially on the group, but I think she would say that we should withdraw from NC Sarah. So I've heard that we should get out of this agreement.
And there was a reason why we were one of the last states in the country to join. And then I think it was with some reluctancy that we entered. And I've heard also, I'm not a part of those conversations, but I've heard that they're happening.
Okay, well, does anyone have I mean, I think one of it sounds like we have more questions about this. I, for one, would like to know what the MOU from Massachusetts does in terms of the ability to enforce our laws, our consumer protection laws.
Laura, can I jump back? I think one piece, if we were as a group to advocate for withdrawing from Sarah, thereby resuming oversight of all of these for-profit schools, I would say almost by default, you would have to enhance resources or resurrect the EAB to deal with that influx under the current structure. It just would not be a workable model to withdraw from SARA, have all of these additional schools with the existing baseline resources.
And it sounds like Rosen doesn't think we should either. It sounds like he thinks we should just become more active members and try to build infrastructure within that context. Okay, does anyone else have any more thoughts on this? I'm not sure, what's the outcome of the group on this? I mean, I get the sense from the group that we want our consumer protection laws enforced, but the question is, what's the best way to go about it? And if staying in NC-SARA is not effective in that regard, but then the question becomes, can we, as a practical matter, get out of it at this point? Is that sort of summarized?
Yeah.
We can if we want to.
Yeah, but after listening to Casey and knowing the makeup of our legislature and direction we go, adding resources is I'm glad you mentioned that, Casey, because we know that that's a heavy lift in itself.
Right.
So I think we need to find out more about the Massachusetts Memorandum of Understanding and see if it's something that fits us.
But I agree. I think this might be millions of dollars that we just don't have that would be better spent on some other piece of our work.
Well, can I make a suggestion? Can we suggest that best practices for should be included to the extent that our involvement in SARA would lead to clear complaint procedures, refund policies, bar institutions. In other words, that last piece of that, that's our goal, and that we think that the state should have a greater involvement in NC-SARA to ensure that. And then if in doing so, the state later thinks, okay, we can back out of this, and this is how, that would be the next step kind of deal.
I think that's brilliant.
Brilliant. Okay. Anybody else think that's a useful way to approach this?
Mm-hmm. Yeah.
Okay, what about best practices number 5?
I don't know if everybody's familiar with the college scorecard and the enhancements that have happened to the college scorecard over the last 3 to 5 years, maybe. But my question in best practice number 5 is, are there particular pieces of this that they think aren't covered in the scorecard? Or is it a school's requirement to like put the link to the scorecard on their webpage or something? Because again, I think a lot of this information is available already. So I think there's if we feel like a piece isn't, we should talk about that specifically. But if it's more about general consumer disclosure, I would want to make sure we're not, once again, just not duplicating things that are out there, because that does make it more confusing for students if they're getting, again, multiple sources of information and all that.
May I jump in here? This is Audrey from Star Lab. I wanted to offer possibly a framework for thinking about the data that's available based on what I understand Nick has been talking to this group about. My understanding of Nick and Kim's recommendations about collecting student loan debt was that it would be helpful to have a picture over time of how student loan borrowers are faring once they leave school and are working in Wisconsin, some sort of way to measure students' progress towards loan repayment as they're employed in Wisconsin. And that seems to me like it's sort of built into best practice number 5. But in addition, as Kevin is pointing out, there are all of these other things in best practice number 5 about program level information, which is in part in the college scorecard, and institution level information, which is also in part in scorecard and in iPads. But I can see that the unit of analysis or the level of analysis might be something that could help us think about the different types of data that are available and ways to avoid replicating available information.
I just wanted to, as part of this discussion, talk a little bit about disclosures and consumer behavior. And there's some things that we know about this. And one of those is that when you show somebody a range of salaries, like for instance, I was just looking at one that said between 19,000 and 59,000, every student views that they're going to be the person that gets the 59,000, right? So I'm not sure how useful even the current scorecard is to students because they all are looking at this with rose-colored glasses. And then there's a second layer of problems with a disclosure or a scorecard or any type of comparative mechanism in that, especially when it comes to for-profit schools, they will tell somebody, oh, that scorecard's outdated. Actually, things are much better. It just hasn't shown up on there yet. And every student with their rose-colored glasses is going to say, oh, good. You know, that did look bad, but since you're telling me it's actually more likely that I'll make $100,000 a year, I'd rather believe that. So while I think that data is useful for regulators to be able to see what's going on, I don't think that disclosures are as useful for students.
I also think some parts of the scorecard help or contribute to schools confusing priorities. For example, if they're being measured on how much money their graduates make, are they going to be investing more into a specific type of degree programs that generate the most salaries for students? So for example, they're going to invest heavily in their STEM programs, but their liberal arts programs are going to suffer. So I also have concerns about how we're using school information to help students create an assessment and what that does to the priorities of the schools that are trying to get good scores on those scorecards.
I'm just going to throw in here the philosophy that we can do all we can to try to help people make the right decisions, but they're still going to make decisions on their own. And I think our focus has to be on helping them through the process of student loans, like what we're here for, more than thinking we're really going to help them pick the right school.
So we have 30 minutes left, and what I'd like to do is get some time in on talking about these two buckets in the context of the worksheet. And so, you know, what I'm taking away from this group is that we do want to have some sort of enhanced regulation on the proprietary school market. And this best practice framework was a way to have that conversation. There's a lot of unanswered questions for us here. So, so I wonder, and then the other piece is the ombudsman / borrower bill of rights framework. And so just as a baseline, am I correct that those are the two recommendations that would come out of this group, is heightened regulatory framework of proprietary schools and then the ombudsman? And I know we wanted to talk actually also about Karen's legal advocacy initiative as well. Does anybody have a different view of where our votes would come down?
I don't think so. Did Laura get kicked off?
Oh no, someone has to take over. Do we need to vote on that?
I think maybe voting in the negative, right? I don't think anyone voiced that they didn't want those two things.
So to answer that question, yes. When I was doing this worksheet, those were my 1 and 2.
Yep, same.
Yeah.
We have so many great proposals here. If we're able to sort of bundle them into the 2 buckets and incorporate as much as possible, I think that's a great direction.
Yeah, I think the Bill of Rights can cover so much ground.
Mm-hmm.
I agree.
So this is Michelle, and I've been monitoring all 3 meetings, and I do not have any of the subject matter expertise. You guys are doing a wonderful job facilitating without Lara and mean to move forward. I know she mentioned right before she got booted out that it sounded like besides the 2 categories, the ombudsman and what would be encompassed in that, that there may have also been another idea that Karen was yours or some assistance. Do you want to start the discussion about that so we can kind of take notes as to what people want to see pursued with that, to incorporate that into the 2 proposals she'll have to complete to move forward, but how that might incorporate itself into those 2 buckets?
Sure. My suggestion was to try and get at this issue where services meant to assist student loan debtors or borrowers are frequently missing the population that we want to aim at most here, right? Which are people of color, who we've already seen through the research that was presented earlier, disproportionately impacted by crushing student loan debt and being taken advantage of by for-profit colleges. And my suggestion is, in a nutshell, that rather than locate all of the advocacy services for targeting that population in Madison, would be to just meet people where they're at. And where low-income people and people of color are going for help already are the legal services organizations that already exist in Wisconsin. And as my proposal mentions, 69% of the state's Black population is in Milwaukee. So locating some level of student loan advocacy in the city of Milwaukee or Milwaukee County, to me, is a no-brainer for us. And then add to that the organizations, the legal services organizations that I mentioned, have already gained the trust of those communities. Wisconsin Judicare in particular with our Native American tribal members, and legal aid with the city of Milwaukee and Milwaukee County's Latinx and Black populations. So my suggestion would be, rather than have all the help for debtors have to be over the phone, to put actual human beings in those organizations that already reach those populations in our state.
Hi, everybody. I'm back. I have no internet, so I'm on the phone. My apologies.
Oh my
I don't know where we left off.
Well, this is Michelle Lara, and I just had Karen summarize her proposal to see how you'd be able to incorporate it into your other buckets. So thank you for being back. I'm silencing again.
I'm so glad you're here. So I didn't mean to interrupt. Karen, go ahead if you're doing that.
I think that I pretty much summarized both why I think that this should be a consideration, and about the fact that it would help reach some of those vulnerable populations that we had previously discussed being a target of our efforts here.
Does that fit in the ombudsman's office? Is that what you're thinking, Karen?
Well, I kind of said that we could either do a bifurcated model right? Where we have an ombudsman in Madison who's working on the oversight and regulatory piece and maybe have one staffer located there to man the phones, and then to locate these 3 advocates across the state. In the northern part of the state, the southwest part of the state, and then in Milwaukee, so that people could obtain some face-to-face help with these issues through organizations that are already used to working with these populations.
Karen, I think that's a great idea. Yeah, part of what I wrote, I like yours better than part of mine, but it covers kind of that same topic of you have these student loan advocates that are not just enforcing regulatory authority, but assisting borrowers through the difficult situations they're in. I would just like to add, I like your idea about having people around the state, but I am curious of your thoughts about also making sure that there potentially could be budgetary considerations for public service announcements and sharing this information in secondary schools and at colleges so that the citizenry knows this service is available. Because like you said, there are people that already use those services that will find it, but how about people that don't use services that could benefit, letting them know it's available? I think that's an important component that could potentially be missed, and if people don't know about it, then you won't get the maximum use of it.
Yeah, so Legal Action of Wisconsin, which covers that southern part of the state, they already, and so does Legal Aid, have partnerships with a lot of secondary institutions because of our grant funding. So we would kind of be getting more bang for our buck by taking advantage of the other funding that these organizations already have for publicity purposes. But I do agree with you, Kevin, that anything that we do needs to be well publicized so that the people that might not be touched by it otherwise could find out about it.
So on that note of connecting people, though, should we have, or would that be appropriate through the DPI or through CISAs, or I mean, using those networks that are already in reaching the students at the high school level?
So this would be aimed at existing student loan debtors, the same way that the Ombudsman's office overwhelmingly is aimed at consumer protection of that population. But certainly taking advantage of having these advocates be able to, for instance, go to a college planning session at a school that has low income students and talking about what parents need to be aware of as they're preparing their students for school is something that they could do rather easily.
You know, one thing that can, and I read your paper, but I missed your discussion about how to interlink it with the ombudsman. You know, the distinction I see is a state versus private, right? So one thing I see with respect to your proposal, which I think is excellent, is it leverages resources and knowledge and expertise that already exists and it's around the state, and that makes good sense. When it comes to an ombudsman and a borrower bill of rights, you're talking about, in most states, you're talking about a series of regulatory frameworks that entity has the ability to enforce and license. And so it's both getting, it's both meeting with the student borrowers and making sure they get the right information and enforcing rules, but also regulating the entity. And I think of the student advocate in a legal sense as a lot farther down the chain, the supply chain, farther down the chain of events, right? And which isn't to say it's not important, but an ombudsman, I think, is going to take a more holistic approach than a legal aid attorney would have the ability to. So it makes me think that we could get at it through partnerships or grant opportunities through the ombudsman's office to legal advocates referral service, if you will, of licensed legal advocates to help students once they've been identified as needing that need. Did you say that already? Is that what I missed?
Yeah, it's actually part of the recommendation. So I just say that it would be employed to augment the work of the ombudsman, right? So having kind of a synergistic situation where the ombudsman's office could fund these advocates, and then the advocates would report back to the ombudsman's office so that patterns could be caught, right? So that these bad actors could be made to heal, so to speak, sooner rather than later. And I also think there's a built-in advantage to kind of having these ears to the ground located in these organizations rather than in Madison entirely, right? So this isn't to say that we wouldn't have the ombudsman, right? It's just as an addition or a sub-grantee of the state.
Can we spend 15 minutes, our last 15 minutes together, talking about the Ombudsman Borrower Bill of Rights and all that we just discussed and the predatory regulatory framework in the context of this worksheet? And again, I'm going to do my best to write this up. And my takeaway is that these are our two proposals. Folks like the best practices with the caveat that the SARA best practice is convoluted, and the 90-10 rule, we're going to sort of table that until we have a better understanding of what that means. And I'm trying to remember, there were 6 best practices. I'll have to go back and look at my notes on the other 4, but I think the other 4 we were in general agreement that they were useful and that we were going to bake in some marketing prohibitions. And then when it comes to the Borrower Bill of Rights, we're talking about licensing, prohibited practices, and ombudsman, and then potentially a grant for a student loan advocate. Does that sort of summarize where we kind of we've landed as a general matter?
I think so.
So can we talk about the Borrower Bill of Rights in the context of this worksheet? We'll try to do it for about 8 minutes, and then we'll switch to the other one. And I hope that's okay with everyone. I hope everyone feels, there was a borrower liaison recommended by Casey and a student advocate recommended by Kevin. So a lot of these are similar, and I appreciate there are some distinctions, but I hope that folks are okay with sort of talking about them in the aggregate. And when I write about it, I will go back to each one's papers and try to extrapolate from them as well. Okay, so with that, the decreased cost of attendance for students, do folks feel like the BBOR and an ombudsman would get to that piece? It's not a front end solution. It's after they've accrued the debt. So I don't think that one in particular would address that. Does anyone disagree with that? So decreasing existing debt burden for borrowers.
I agree with the same point you made on the last one, that it's likely more back end. So I don't know if, hopefully it would prevent some negative issues, but I don't know if holistically it would decrease debt for people on the front end. I think some of the student advocate work could reduce interest paid and other long-term debt situations. So I don't know if you want to reference that in some point, but I don't know if it directly reduces principal debt significantly.
Okay, what about decreasing racial and vulnerable population gaps? you know, the marketing practices, the prohibited marketing practices that Renee talked about. I guess that goes more to the for-profit. I'm wondering in terms of the predatory practices of lenders.
I asked earlier on in the chat, how do we measure whether or not we're making an impact on decreasing the racial and vulnerable population gap?
Sure, Audrey has something to say about that.
I do. But I think that some of the recommendations that were in the paper we were just looking at would get at a framework for holding or shedding some light on how institutions are providing affordable and equitable educational opportunities to students. I really appreciated what Karen said earlier about the use of data for consumer information versus the use of data for accountability. And I think, Senator, what you're getting at is looking at how we can use data for accountability. Does that sound right?
So I do think some of the BBORs have data collection requirements in it. So certainly we could know the impact. I don't know. I'm not sure what prohibited practices are in there that would address the disparity. So moving through these, increase the ease of student loan management. I think it's safe to say that having an ombudsman, that's the whole purpose of the ombudsman, is to create some more simplicity. What about completion rates? Does anybody think this would have an impact on the completion rates?
I mean, it could, right? Because if someone's in default on their existing loans, until they get out of default, they can't borrow more to be able to complete their education. But I think that is a slight impact.
Hey, I wonder if you could talk a little bit about your proposal with re-enrollment programs and if there was any way to marry those into the BBOR. Isn't that your proposal?
I think that was Shannon Halsey's proposal. But I do agree with Shannon Halsey's re-enrollment would actually get at this increasing completion of post-secondary education. I think because for us at the tribal college, that is one of our biggest problems is if students are in default and they're coming to us, they cannot re-enroll until they have a plan set up with the college, and or we end up taking the hit if the default is through us.
Lucy, thanks for that. Do you think that re-enrollment program could be built in at all to the proprietary school piece, or it's really kind of a standalone issue, isn't it?
It is, but some of our students are coming from those proprietary schools that they've been targeted, and they get into these schools and then they build up this debt and they default and then they can't come to us.
Mm-hmm.
So it's kind of a trickle-down effect.
Does anyone else have any thoughts on the re-enrollment proposal of Shannon Halsey's paper?
I would like to see that particular piece come into play somewhere. And I think in the proprietary schools, it might be the best one to put it into. Because the only other one that might be under the Bill of Rights, but I don't know how you would word that into the Bill of Rights.
Am I right, Lucy, that re-enrollment program was an institution-based program? She gave the example of Wayne State University forgiving the first $1,500 of debt.
Right.
So is it really, what is the state's role in that re-enrollment program?
In the one that she's proposing?
Mm-hmm.
It looks like it was just with Michigan. And it looks like it was just with Wayne State.
But in other words, it's a funding mechanism. It's a funding role of the state. The
Right.
state helps the university.
I think the state, because it talks about the Detroit area and the non-completers, and the program is called the Warrior Way Back, and it helps institutions write off up to $1,500 or the equivalency of like one course of debt from that student's current debt.
Yeah, so that's more of a fine. That's not so much a consumer protection issue as much as a
Right.
Yeah. Okay. Let's Okay, so let's quickly move through the last few of these. I guess why don't we move towards the end here? Some of the stuff I think is pretty straightforward. I'd just like to hear any feedback on the lift of this particular, the BBOR and the ombudsman. If anybody have, maybe Senator Smith in particular, you might have some feedback on what the likelihood is of getting a BBOR and an ombudsman through the legislature.
You could start with what we mentioned earlier, with whether there is cost involved. I think the Bill of Rights, for the most part, we could argue doesn't have a cost to the budget mostly. So that might be the easier lift, and then moving on into the ombudsman's office, which of course does have some creating positions and cost involved, which isn't going to be great, but this next year is going to be a tricky, difficult year in a lot of ways. So that's what I'd have to add to that, I guess.
Any other thoughts from the group? And since we have limited time, how about the same last question, the lift on the the best practices with respect to proprietary schools? Does anyone have any thoughts on that?
Well, speaking, specifically to Representative Hesselbein's proposal to reinstate the EAB, there wouldn't be any cost to doing that, though I still think the lift is more of a challenge because there was, there's a reason why the legislator supported this move to begin with. I think it's just important to note that as a self-funded program, making changes on this level would cost nothing.
The actual challenge is the philosophy between private and public and profit and nonprofit, and
yes,
the political philosophies and our fights that we have in this building.
That will be the challenge, not the money with this piece.
Yeah.
Which could be equally difficult. All right, well, we have a couple more minutes. Does anybody have any parting thoughts or concerns or issues that they want to raise about these two themed proposals for the task force?
I just have a procedural question. So Laura, you mentioned that you were going to write this up, which seems like a ton of work. So thank you. But will we get to be able to take a look at it before it gets submitted to the larger group?
You know, that's a great question. Oh, did someone speak? Cheryl, did you say something? So Cheryl, I don't think I'm disseminating it to this work group for feedback before I present on it. Is that right?
That's correct. My understanding is we will go through it and write it, and then just our internal work group will review it, and then it'll be presented at the meeting number 7.
I think we have we would have a walking quorum if I sent it out to the full group.
Correct.
One of my favorite legal terms.
Legal.
But we have copious notes. Thank you, Sophie. You're the most amazing note taker. And you guys can see all of those in the chat, and she'll send those out again. And Cheryl is here helping me too. So I will, and it isn't as much work as you think, because it's only supposed to be 2 pages. So the challenge is to get all your thoughts down succinctly in 2 pages. Having said that, I am going to write it up and present it, but folks are certainly willing, if they're willing and able, to chime in at the meeting, you know, put some meat on the bones where I've missed, you know, hopefully I won't misstate anything, but certainly if you want to add to it, you can. Any other questions? And Karen, I had the same thought, because I would rather have your feedback, but I don't know how to do that without creating an open meetings issue. But I'll double check, and if there's a way I can disseminate it to the group, you know, maybe I can do that, and I will. If I can, I'll absolutely do that. All right, well, I've enjoyed this. It's a good conversation. I think we've got some great proposals for the governor. So thanks, everybody, for your time and your interest and your passion. It's super important. And
Thank you, everyone.
Yeah.
Thank you.
Thank you. Thank you. Take care.
Bye.
Bye.
Thanks.